versus In Re Forfeiture. All right, Mr. Carney, whenever you're ready.
Yes, Judge.
I'm guessing you want 5 minutes for rebuttal?
Yes, Judge. Please.
Is that good?
That's perfect. May it please the court. My name is Adam Carney, and I represent the appellant in this matter. I'm requesting that this panel reverse the circuit court's ruling that the ex parte application for probable cause determination of seized property was timely filed, and remand this matter with instructions to dismiss the underlying action with prejudice. Already asked for 5 minutes for rebuttal. The crux of this appeal is quite simple. It's how are we to count business days under Florida statute 932.7032A. That statute specifically states that when a seizure of property is made under the Florida Contraband Forfeiture Act, the seizing agency shall apply within 10 business days after the date of the seizure to a court of competent jurisdiction for an order determining whether probable cause exists for the seizure of the property. We're not contesting that this isn't a forfeiture action. The operative date for this matter is December 17th. So how do we count the 10 business days starting from December 17th? And that's what we're here seeking relief from the court. I want to point the court to page 9 of the appellant's initial brief. It contains a table which we submit to the court is a reasonable interpretation of how to count business days under that statute.
Well, I don't think the parties disagree that on the math, right? It's just on which days constitute business days.
Yeah, that's correct, Judge. So my opponent's position is that an announcement of the governor made on December 13th that was posted on the governor's website, not signed, no executive order, no anything, essentially stopped down the business days.
I always thought business days meant Monday through Friday,
Well,
even though many businesses are open Saturday and Sunday. But business days are Monday through Friday, and legal holidays are legal holidays. And not, and according to the rules of judicial administration, not business days. So, go ahead. Just because some businesses are open on Saturday or Sunday doesn't make Saturday and Sunday business days.
I don't disagree with you, Honor, on that.
I mean, business days, I think, have commonly always been understood as Monday through Friday, not when the actual business is open.
I agree with that, Your Honor.
Yeah, so I mean, your chart might have actually given more credence to your opposing counsel's argument than you really needed to. I mean, you could have made the argument, look, business days is a commonly understood term. There's no court in Florida that has ever said that term is ambiguous in any way. It's Monday to Friday, days of office days of doing business, when businesses typically and historically, most offices were open for business. And so under the statute, you count off 10 of them, and that's how long the department has to file their petition.
I don't disagree with that either, Your Honor.
I didn't think it would, but I mean, it's just.
I know we're yeah.
And just to further address my opponent's likely argument that I'm assuming she's going to make is that she's going to, say that the Department of Highway Safety and Motor Vehicles is the subject of the statute, which is 932, the forfeiture statute. And there is nothing contained in the statute that directly says the Department of Highway Safety and Motor Vehicles or Florida Highway Patrol is the subject of that. In fact, I'd contend that in Collier County alone, there are 5 potential seizing agencies that could seize property under this Forfeiture Act: Collier County Sheriff's Office, Marco PD, Naples PD, Florida Highway Patrol, and FWC. FWC and Florida Highway Patrol, I would submit are state agencies, but the other 3 are not. So they wouldn't even be controlled by if the court is giving any credence to Governor DeSantis's announcement on December 13th, that this statute wouldn't be able to be applied uniformly as it pertains to, those 5 agencies in Collier County, let alone the rest of the state. I would further like to point the court to the De Gregorio case. It says that forfeiture actions are considered harsh extractions. The court has long followed a policy of strictly construing forfeiture statutes. Any ambiguity in the statute must be construed against forfeiture. Further, because the statute here provides for the deprivation of a property right, its procedural requirements cannot be regarded as immaterial or as a matter of mere convenience. So unless the panel has any, further questions, I'll, reserve the 5 minutes for rebuttal.
Okay. Anyone? All right, I think we're good. Thank you. Counsel, when you're ready.
Thank you, Your Honor. Appreciate the court hearing this appeal this morning. As far as the court stated business day is Monday through Friday. And I don't think there's any disagreement here as far as business day being Monday through Friday, regardless of whether a business is open on Saturday or Sunday. And for computation of time, neither of us considered any Saturdays or Sundays. The issue here is whether the business day fell on January 5th or whether the business day fell on January 6th.
I think Judge Kelly's point was if you're contending that just because a certain businesses are not open on Monday through Fridays, that makes them holidays or makes them not business days. The converse, to be consistent, would mean that if a business is open on Saturday, Sunday, that is conversely a business day.
And I understand what Your Honor is saying. And for my purpose of the argument, we here, Mr. Carney and I, did count the days as Monday through Friday. And my argument is that on the December 13th, when the governor issued its statement saying that all state businesses would be closed, we did not count the day that we were closed as a business day because we were not in business. And
what within the statute would alert anyone that an agency, whether proceeding upon an email announcement from the governor or from their department head or whoever, what in the statute would alert the reader to understand that the amount of time between when their property is seized and when a petition needs to be filed in order to follow up that pre-adjudication seizure of private property, what in the statute would tell you that you necessarily include and add on to business days these decisions to close the office?
Your Honor, the statute is silent. 932-703 is silent as far as—
Is it ambiguous?
It is not ambiguous, Your Honor. And so I say that if Your Honor is to consider business days, the statute does not account, and it's not we look to the legislative intent. The legislative intent is to ensure that these things are filed expeditiously so that the process can be moved forward. And if the state is seizing a piece of property, and that the court has an opportunity to decide probable cause as quickly as possible in order not to deprive the claimant of any type of property. And the statute is not ambiguous. Just because it doesn't contemplate every available situation does not make it ambiguous. So we all agree that the statute's not ambiguous.
What about this situation? Let's say the governor issued an executive order, which is a lot closer to, I wouldn't call it a legal holiday necessarily. For the sake of discussion, it's something legal. He has more than just an announcement. Let's say he just gave all executive branch agencies under his purview the whole month of December off, the whole month of January off, or both. Would the application for a probable cause order not be due till February?
Your Honor, I understand what you're saying as far as the governor, but we're talking about reasonableness here. If the governor decided that for an entire month it would close all state agencies, as far as reasonableness, right, it would not be reasonable to hold on to a piece of property for 30 days without making any action. And I think that the fact that what was reasonable in this case is that the date, it's 24 hours as far as the statute is concerned. And in certain situation, what is reasonable? If there was a hurricane in a particular county and all electronics were shut down and nobody had access to something, would it be reasonable to file it on the 6th day? If some random shooter comes into the building and decides to hold everybody up for 24 hours,
Ms. Attila, the forfeiture act, in terms of when this point of entry is supposed to happen, when this petition is supposed to be filed, the Forfeiture Act has presumably considered that and said 10 business days. That's it. So if they happen to close for a couple of days within that, fine, you better make sure you get your petition filed before then. But nothing within the governor's statement here purported to extend any statutory deadlines, right?
And you are correct, Your Honor. Nothing in the statement that the government put out extended any type of deadlines. But again,
purported to.
Correct, Your Honor. But then again, we have to look at the statute and the wording of the statute. And the statute says specifically that when a seizure of property is made under the Florida Contraband Act, the seizing agency must apply within 10 business days. So seizing agency being that they are the subject matter of that statute basically says the seizing agency's business days, the seizing agency within 10 business days after the date.
No, it does not. It does not include a qualifier on 10 business days of the agency. The subject of the sentence is the seizing agency shall apply. Okay, there's your subject, there's your predicate. And then here you go. Here's the qualifier within 10 business days. But it doesn't say anything about how the statute seems to utilize a commonly understood term, business days, which you have just said is unambiguous, in order to qualify about the subject and the predicate. There's nothing, there is no within 10 business days as measured by the seizing agency, or within 10 open days of the seizing agency. It's just 10 business days. Which makes sense, because if it is indeed unambiguous, and I think you're probably right, that's a readily computable and easily understood term, and it's easy. Okay, seized on this date. How many? Look at the calendar. How many Mondays to Fridays are there in between then and when the petition needs to be filed? Okay, that's your deadline. You might be closed on that 10th business day, so you better get it done before, because the statute says within 10, within. Why isn't that a reasonable construction of this?
And I'm not saying it's not reasonable, Your Honor, the way the court is reading 10 business days is 10 business days. Our argument is 10 business days can basically, you can construe 10 business days based on the information that you have in front of you. There are tons of cases in which the courts have closed. For example, the courts closed on December 23rd.
Yeah, but that's the court. And that goes to your point that you said, well, it is the subject, to use, I think the term you described, is the agency, not the court. But the agency is a party before the court. Since when does a party dictate which days to count? Since when does a party have the ability itself to toll its deadline by closing its doors?
And Your Honor, the same way that the courts have designated certain days on their calendar in which they close their doors, in which there is no action being that you can't move forward. And
so yes, and so okay, so saying the courts, if the courts can close their doors and essentially, I'll just concede for the sake of your discussion, and essentially override the rules of administration, then a state agency should as well, but state agency is a party. Let's say Ebenezer Scrooge is a party, and let's say Ebenezer Scrooge, after being visited by the ghosts of Christmas future, gives Bob Cratchit the entire week before and after Christmas open, after Christmas off, and Scrooge goes home too. And does that mean that's a holiday? Does that mean it's a holiday because Ebenezer Scrooge is a party?
No, Your Honor, and I think that now the court is looking as to what constitutes a legal holiday. And we're not making arguments here that that day constituted a legal holiday. We're making the
Okay, so you're saying, Scrooge and Company is a party, and they and that makes that means that those days are no longer business days because he gave Bob Cratchit all that time off, right?
that as a party to the case, Your Honor, we're looking at 10 business days. 10 business days if Ebenezer Scrooge decided that they gave Cratchit the 10 days afterwards off, if I think that's what the court is saying, does that mean that it doesn't count as a business day? We
Right.
are saying that 5 days off, not counting 5 days as business days, you have to look at the reasonableness behind it. And then in this particular case,
But I'm talking about the entity. I mean, you're saying that, okay, let's say it's one day. I'm sorry. Let's say Bob Cratchit gets the 23rd and the 24th off. And so now the 23rd is not a business day anymore because Scrooge and Company is a party to the action and they're the subject of the action. And therefore their filing deadline is told for the 23rd because that's no longer a business day because Bob Cratchit got to go home.
right, Your Honor, but we're talking about, fictional characters, and I don't know.
Yeah, so you're drawing a distinction between, are you just drawing a distinction between a private sector party to the action and the state of, and some state entity?
Yes, I'm drawing.
So all state entities, so if it's any state entity that's a party to an action can just, can the secretary of the agency declare that everyone gets the 23rd off and then thereby remove from that day the status of business day?
And I'm looking at it from the standpoint, Your Honor, that the governor of the state of Florida issued this
Email?
mandate, this executive press saying that basically that all offices in the state of Florida for all state agencies will be closed on the 30th, which is really the date that we are going back and forth on. Closed on the 30th.
Didn't refresh my memory. It's been a while since I looked at it, but didn't the governor's communication just say state employees can have the day off? Or have the day off? Or did it actually close everything? Not that it matters, but just for the sake of being accurate.
It says the state offices will be closed.
Okay.
It said the state offices will be closed on that date, and so therefore there was no business running in any state agency. And as far as the business,
Well, what about those are the agencies under the governor's purview, which don't include, as the appellant has pointed out, other agencies that also have forfeiture authority. So for those agencies that the time was not told, if they had apprehended the truck on the same day, the time would not have been told for them. The county.
Your Honor, their 10 business days will be operating on their 10 business days. Obviously, they're in business, so therefore they're counting those.
Which goes to my point, which is that a party can just manipulate their own deadline by shutting their. What if they just say we haven't really gotten our ducks in a row to make this application what we want it to be to ensure that we get an order of probable cause. Let's just shut the office down and that'll toll our time.
And then I think, Your Honor, a private party, a party to an action doesn't have the right just to say willy-nilly, I'm just going to close the office. We, in this case, did not just decide on our own that we're just going to close office just to, and in no way try to avoid any type of deadlines. This was an statement.
Right, but what the department did do was it then just simply assumed that it would thereby have an extension and more time from what the statute said. You all just assumed that because the governor said, hey, you're getting a couple extra days off, oh, that means we have a couple more days to file what Florida deadline that's set by Florida statute, correct?
Yes, we looked at it as far as business days, Your Honor. We were not in business on that day based on the governor making the release saying that all state offices would be closed. And therefore, Your Honor, we looked at it similar to when a court has the authority, any day observed as a holiday by the clerk's office. When the clerk's office is closed, they're not in business, or designated by the chief judge. When the chief judge designated holidays such as Yom Kippur or Good Friday, in which there
Isn't
are,
that actually in the rule of judicial administration?
it is in the rule.
That's
of
enumerated.
It is enumerated in the rule of judicial administration 2.51.
That would by inclusio unius est exclusius ulterius. It's a little early in the morning for Latin, but they preclude the governor or the secretary of the agency from having that authority to declare a day a holiday and thereby deprive it of business day status. I'm looking at some of the authorities you cited, and they seem to potentially undermine your argument. Black's Law Dictionary, business day is a day that most institutions are open for business, usually a day on which banks and major stock exchanges are open. So that tends to suggest that it must be a more universally applicable standard than the one you're proposing, which is a day that an institution that is a party to this action is open. But were most institutions open for business on the 23rd?
On the 23rd, I can tell the court that the courts were not open on the 23rd for business. And private entities, of course, they make their decision on whether they want to open or close for business. And I can't speak for Mr. Carney's office, who is a private entity, on whether they were closed or open on the 23rd. And I think he did not, in his computation of time, include the 23rd as a business day. I guess the dispute is December 30th, which is that Thursday, on whether that constituted a business day. And argument is that December 30th did not count as a business day because we were not in business.
Are most institutions open for business on the 30th of
on the 30th, to my knowledge, it's understood that the courts were open for business on the 30th. Obviously, some.
But you cited Black's Law Dictionary says most institutions, like generally speaking, business, a business day is one where most institutions are open.
Right, and I can't speak for private entities because
I mean, it seems like to me you want to change the meaning of business day to, well, it could be Monday through Friday, but you have to look at what business we're talking about to see what their business day is.
And I'm not trying to change the meaning of business day.
Well, you are.
What I'm trying to request the court to consider is that business days did not contemplate every single situation in which business would be operating.
No, I think the point of using a generic term like business days that's well understood, that's been traditionally understood by everyone as Monday through Friday, is to avoid exactly the kind of debate we're having here.
And I also think that the statute can be in a situation where there is, let's say, an exigent circumstance or a situation in which there's a disaster of somehow. I think the court, as far as reasonableness is concerned, can look at the situation and determine, yes, I understand that Thursday was a business day, but we have a situation in which we had a category.
Ms. Attila, candidly, yes, and I'm only speaking for myself here, if what you are suggesting was, even if what you were suggesting is correct, which is that we ought to read some kind of reasonableness exception into the statute for extraordinary circumstances, I would think that it would cut against the department in this context where you've got a pre-adjudication seizure of private property rather than extend it.
And I understand that the court's concerned, and I understand the court is saying that in this situation, because this is a pre-adjudication taking of someone's property, that business days is just that, Monday through Friday, regardless of the days or what happened or any type of exigent circumstances. But again, considering reasonableness, considering that the governor did issue this release saying that the offices were closed, our position is that our office was not in business, therefore it did not count as a business day. Therefore, we filed it at the very first opportunity we had, which is the very next day, contemplating the quickness in order to get it before the court, in order for the court to address the probable cause part of that. And another part of Mr. Carney's argument that I would like to address, he's asking that the court dismiss the underlying action with prejudice. The court finding here that the department, if the court should find that the department did not meet the 10 business days and was outside the business day, does not automatically dismiss the entire underlying action with prejudice. What it does is it addresses probable cause and whether the property itself should be kept by the department or returned to the claimant. It does not forego all the entire forfeiture action. That's why 932-703 separates the two parts. First, it addresses probable cause and whether the department had probable cause to seize the property. Then it addresses forfeiture. Just in the 10 days requirement for the court to for the party to send in the ex parte application for the court to make finding of probable cause is to determine whether the department shall continue to keep that piece of property in its possession, depriving the owner of such property while the forfeiture action proceeds forward. And if the court decides in this case that the department did not meet the 10 days requirement, and I say if the court finds that the department did not meet the 10 days requirement per statute, that only allows that the piece of property be returned. It does not dismiss the entire action.
Okay, that's a good point to stop. You're at the end of your time. That worked out well. Thank you. Mr. Carney,
Yeah,
any rebuttal?
Brief rebuttal, Judge. Just in the event that this court would give any credence to the governor's announcement of state closures on the 23rd and the 30th, what we don't have is anything in the record of evidentiary nature to support that the agency was in fact closed on those days. So even if the Governor DeSantis closed the office, the department didn't file an affidavit, provide testimony, or anything of that nature that would allow the circuit court to rely on that outside of argument of counsel. So with that, I thank you for your time. Unless
printout, but could you print out, right? The printout of the triple press release or the website got in the record in the appendix, at least. But could you address Counsel Attila's argument about if we were to agree with you and reverse, what would be the instructions on remand? As far as what, just give the truck back or dismiss the entire forfeiture proceeding with prejudice?
Give the truck back, Your Honor.
Yeah, okay.
All right, well, thank you. That concludes this argument.